My dad met Ashley 9 months after my mom passed. He told me that they were actually married, not just dating.
So her claim was that while she was pregnant with their daughter, he poisoned her through heavy metals.
They disproved all of the allegations like every other time, but that started the real problems between Ashley and Doug.
He's saying the neighbor came over, female neighbor. It was a domestic. She shot her husband.
All right, we want to turn now to Florida for our coverage of the Black Swan murder trial. Defendant Ashley Benefield was back in court today for a motions hearing. The former ballerina is expected to go to trial next month for the 2020 shooting death of her estranged husband, Doug, amid a bitter custody battle. Benefield claims that she shot in self-defense during a domestic argument, but police say there's no evidence to support that theory. In fact, it supports the opposite. Well, in today's hearing, the state is arguing a motion to compel a discovery deposition from Benefield's psychotherapist, Dr. Barbara Russell. Now, she's on the stand now, so let's get you inside that courtroom.
Ms. Benefield had her own room?
Yes.
Did you see her on a daily basis?
Most days, briefly.
Did she use your bathroom?
She had her own.
It was in your house?
Of course.
Did she use your kitchen?
Yes.
And just to be clear, your house is not a shelter or anything like that. It's a personal residence?
Correct.
No further questions, Judge.
Mr. Taylor, questions?
No questions at this time.
All right. And it was Mr. Seaman. Saman. All right. I'm going to put the, there you go. Yes, sir.
Thank you. Dr. Russell, I want to ask you very brief questions because I don't want to open any doors, so I want you to listen carefully to the questions that I'm asking. Do you recall testifying at a bond hearing?
Yes.
Okay. Do you recall, well, actually, let me just get right to this. Do you believe that your interactions that have been asked about are protected by the privilege contained in 9503?
Yes.
Are you considered a psychotherapist because you are a licensed clinical social worker?
Yes.
Are all the times that, and you've spoken with the prosecutor before,
Yes.
and one of the times that you were interacting with her was at your deposition, which was, I believe it was held in May of this year?
Yes, May 14th.
Okay. And you testified earlier that Ms. Benefield lived in your home for a time period.
Yes.
And you understand that you're here today because the state is trying to compel you to testify about your interactions with her.
Correct.
And do you believe that your interactions with her are covered by the psychotherapist patient privilege?
They absolutely are.
Have you had a chance to review Florida Statute 90.503?
I did.
Okay. Is it your testimony today that the privilege that you are asserting on behalf of Ms. Benefield is being done so pursuant to the statute?
Yes.
Have you received any evidence that Ms. Benefield has waived that privilege?
No, I have not.
Are you asserting your privilege because the information the state is seeking includes information about any diagnosis made, any advice given by yourself in the course of your professional relationship with Ms. Benefield?
Yes.
I have no further questions, Your Honor.
Redirect.
Actually, Your Honor, now, if I may, I have a question.
Okay.
The reason why I passed the first time, Your Honor, is because Dr. Russell is his witness. And the basic argument is between the state and Mr. Simon. But I do have a question, Dr.
I disagree, but okay, go ahead.
Thank you. Dr. Russell, through your practice, you're familiar with HIPAA
Yes.
and HIPAA's requirements?
Yes.
You're no stranger to it.
No.
You require a HIPAA release before disclosing any material that's confidential and comes under the umbrella of the privilege?
Yes.
Is there a staleness element to HIPAA?
There is a staleness element to HIPAA, and there's a staleness element to any type of waiver that is signed by any client of mine.
Dr. Russell, other than the waiver that Mr. Simon brought to your attention, which was dated in 2020 of October, I believe, have you been presented at any time since then with a fresh HIPAA waiver?
No.
That's all you want.
All right, now redirect.
Are you asserting this privilege because Ashley Benefield asked you to?
No. I'm asserting this privilege because it's a requirement of my license to assert the privilege, as I explained in the deposition.
Okay. How long have you been in this field?
30 years.
In this area?
Since 2009 here in Florida.
So I would assume that you know a lot of colleagues that are in the same business.
Yes.
Correct. Have you known any personally that have moved a criminal defendant into their house?
I don't know.
Relevance?
Well, I think it's beyond the scope of cross, so sustained.
And you said you would require a HIPAA release, correct?
Yes.
That or a court order, correct?
Yes.
Thank you. No further questions.
All right, so here's where we are quickly. I just want to describe Dr. Russell was treating Ashley Benefield for a time, and Ashley Benefield at one point moved in with Dr. Russell. Communications took place. The question is that communications privilege? So that's one of the questions here during this hearing. We'll take a break. We'll have more from out there, so keep it here on Court TV, your front row seat to justice.
Court TV fans, you demanded it. Here we go, do it. So now you're getting more true crime at nighttime.
Oh my God, oh my God.
48 hours on Court TV tonight, 7/6 Central on Court TV.
Tonight on Closing Arguments, our verdict watch continues in the case against Karen Reed. We'll break down what could be having the biggest impact on this jury as deliberations continue.
Closing Arguments tonight at 8/7 Central, only on Court TV. Down.
All right, folks, before we go back to court, let's bring in criminal defense attorney, former prosecutor Marie Pedetta is with us, and trial attorney and law professor Joe Richardson as well. Thank you both for joining me tonight on the program. Marie, I'll begin with you. You heard the issue here. It's an interesting issue. Well, let me start here. We found out here that Dr. Russell was at some point treating this defendant, Ashley Benefield. At some point, she moves in with Dr. Russell. Right there, that seems to create some ethical problems. I know you're in the medical field, a nurse, et cetera. What do you make of that arrangement, that relationship, before we even get to whether it's privileged communications between the two of them?
I think it mixes up the privilege because now they're personal friends. I don't think that it negates the privilege, but I think it's rather unprofessional of the therapist to allow her to move in, and then now she has to testify or not and claim that there's privilege when the privilege is sort of mixed because she lives with you, and that's basically now your homegirl / client. I have a therapist, and I wouldn't move in with my therapist. I think it crosses the line on all levels, and it muddies the waters of what is privilege and what is not.
Yeah, Joe, it puts the court in a very difficult position. Some of the questioning there we heard really goes to the nature of the communications. Okay, the ethical considerations with the two of them living together is one thing, but still, under those circumstances, if the communications are professional, I would think the privilege might apply.
Theoretically, it would, but there's no question that this muddies the water, right? Are they, sitting on the couch in the living room and there's 10 minutes of conversation that's going to be privileged? Or is there conversation that shouldn't be privileged that they, with a wink, wink, characterize as privilege? Is she just kind of hiding the ball and keeping a silo so that certain things don't get out that could potentially convict her? And there's potential for a conflict related to, when you see how, they're moved in together. And so it does create the issue for a potential problem. And I think it rubs against them. But how do you get to, it could be privilege, but how do you get to what's privilege and what's not? How do you parse it out? The living situation makes that more cloudy.
Yeah, and I think you go to the doctor. The doctor seems very clear that she believes it was privileged information. But again, we'll go back into court now. Testimony is continuing in that motion hearing in the Black Swan murder case in Florida. So quickly, let's get back to court.
Okay, thank you very much, ma'am.
Thank you.
Any other witnesses?
No.
Mr. Taylor, any witnesses?
No, Your Honor.
Mr. Saman?
No, sir.
No other witnesses. All right. All right, State.
Judge, the only thing I have to add is that according to the rules of evidence for the waiver of the privilege, it has to be waived by the defendant, not the therapist. So I would argue that that is not a proper defense to this request to take a deposition. And I would also stand by my previous arguments.
Mr. Taylor?
I can go first. Judge, I'll go first on this one.
Okay.
The statute is very clear as to who may raise the objection. It specifically says, and I'll just read verbatim from the statute.
Are we saying raise an objection or assert a privilege?
I'm sorry, assert the privilege.
All right, yes, sir.
And it says here, under subsection 2, the privilege may be, it's 3, may be claimed by the psychotherapist, and this is section D, the psychotherapist, but only on behalf of the patient. The authority of the psychotherapist to claim the privilege is presumed in the absence of evidence to the contrary. So there's no evidence to the contrary, and so my client is fully within her right and frankly required to do this. The other thing that I would point out, Your Honor, just generally speaking, is the evidence that you heard today has not changed from the evidence that was submitted to the court in the form of the deposition or the bond hearing. My client has maintained that she has a professional relationship with the defendant. She's never wavered on that. I think it would be inappropriate to have the state try to get the court to infer something else when those facts are simply not in evidence. The last thing that I would say is that in some of the case law that I provided, the courts have found that if there is going to be an involuntary waiver that's found, and clearly this is not a voluntary waiver, that it is not something that is common, and it's not something that can be invaded without an actual showing. The last thing, and I would talk about the reason for my motion for a protective order, is that the state hasn't established a necessity of why this testimony is required to a point that would overcome what is clearly privileged and what has clearly been asserted in a timely fashion. I won't add anything more than that, Your Honor. I know that Mr. Taylor wants to
The only addition I would have, Judge White, is pursuant to that same statute which governs
All right, folks, we are following some breaking news coming into our newsroom out of Georgia. A search is now underway for 2 missing firefighters. Chandler Kubander and female firefighter Reagan Anderson have been missing since yesterday. That's when Kubander's family say they last heard from him, and they don't believe that he left willingly. The pair reportedly are driving a 2017 Ford Focus with Georgia tag number GEX 655. Now, police believe they're headed to Tennessee to Gatlinburg, Pigeon Forge area. Now, there are reports that the pair might have been involved in a relationship, and online records show that Anderson was recently arrested for vandalism and then released. Of Of course, we'll keep you updated on that story. Coming up next, we're going to hear the defendant speaking in the motions hearing for the Black Swan murder trial. That's going on now in Florida. Keep it here on Court TV, your front row seat to justice.
His action was just to pull out the revolver, and it went off.
Two people accidentally shot.
Alec Baldwin was the actor on set. Alec Baldwin? Yes, sir.
Hurry, hurry, hurry was the motto on the set.
Right away, let's reload.
Alec Baldwin claims he didn't pull the trigger. Well, the FBI disagrees.
It's not going to fire until you pull the trigger.
They really do have to show that he couldn't care less.
The case against Alec Baldwin premieres Sunday, 9/8 Central on Court TV.
Welcome back to Court TV Live. I'm Michael Ayala. We do want to get back now to that motions hearing in the Black Swan murder trial in Florida. Ashley Benefield is accused of killing her husband back in 2020. Well, now they're discussing keeping the paralegal at the defense table. The defense attorney in this case is 74 years old, says he needs a little bit of help. Let's get back into court.
Slightly less than a month at this point, about 3 weeks away from trial. But Ms. Benefield, I did want to have a conversation with you on the record. Are you aware of the document that I'm talking about?
I believe so, Your Honor.
All right, yes, Deputy, can you slide that? Thank you. You don't have to lean into the microphone or yell into it, but it's important that you speak loud and clear so everybody can hear it. I'm going to have questions. Your attorney will advise you whether he wants you to answer those questions or not, and we'll go from there. So do you have a copy of the, I'm going to call it motion, but it says request for paralegal Jack O'Keefe to remain at counsel table?
Yes, Your Honor.
Do you also have a copy of the affidavit of Neil G. Taylor, Esquire?
Yes, Your Honor.
All right, ma'am. If you would just raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, ma'am. You put your hand down. Have you had a chance to review both of these documents?
Yes.
Okay. Do you understand what they are and what they mean?
I believe so.
If you've had a chance to review them and go through them, if you look at the affidavit of Neil G. Taylor, paragraph 4. If you have not read paragraph 4 in its entirety, can you do so now?
Yes, Your Honor.
Okay, you've had a chance to read it.
Yes.
And then if you could look at the request for paralegal Jack O'Keefe to remain, the request that I'm calling a motion, the main document. If you haven't had a chance to review paragraphs 6 and 7, would you please do so?
Yes, Your Honor.
All right, so you've had a chance to read those. Do you understand them?
Yes, Your Honor.
All right, ma'am. Mr. Taylor is obviously a very accomplished and experienced attorney. I won't guess, but I assume you've been a member of the Florida Bar for 50 years?
I've been around, Your Honor.
All right, sir. I want you to rely on your attorney for legal advice, but I want to explain some things and just clarify and make sure that we're all on the same page regarding your choice of attorneys. And I certainly don't want you to think that anything I say is casting aspersion on Mr. Taylor. As I said, he's a very accomplished, very experienced trial lawyer, but the paragraphs that I had you read are the reason why I want to have this conversation. So, if you are ultimately found guilty of some criminal offense, whether it's the charged offense or some lesser included offense, you will have the right to what we call a direct appeal. That's where I'll tell you within 30 days you have the right to appeal and you're going to look at and talk with your appellate attorney, whether it's Mr. Taylor or someone else, about attacking the rulings that were made, the trial itself. So if I granted a motion or denied a motion, if we're at trial and I grant or I uphold an objection or I overrule an objection, if I allow certain evidence in or I keep certain evidence out. All of those things and even more, including all the pretrial rulings I've done and will continue to make, including all the way through the sentence, is part of a direct appeal. Happens right afterwards. And that goes on for some amount of time. Ultimately, if all of my decisions and the sentence and everything else is upheld on your direct appeal, you would then begin the process of what we call collateral attack. A lot of times we refer to it as a 3850 because it comes from Rule of Criminal Procedure 3.850. And in that one, you're attacking how things happen. Not what happened and that was erroneous, but how things happen. And the main complaint that you'll see, or that I'll hear in those kind of hearings, is that there was ineffective representation of counsel. And it could be everything from, and I just use these as examples, my attorney didn't cross-examine this witness properly, didn't investigate this witness, didn't call this witness, they didn't file this motion, whatever it may be. That you're attacking collaterally. That's why we say it's a collateral attack, not the case itself, but how the case happened and how the conviction came about. The reason I say all that is one of the bases that could be cited is that my attorney was not effective. And the concerns I had with the affidavit and the request was I don't know what I'm going to do. I don't know if I'm going to grant the request to allow Mr.
O'Keefe.
I'm so sorry, you're sitting right there, and I've known you since family law. So Mr. O'Keefe, to sit at counsel table. I haven't made that decision yet. I don't know. I'm going to want to hear from your attorney. I'll hear from the state and then make that decision. But what these documents say is, and I'm going to paraphrase, but ultimately what I read these to say is that if the court doesn't allow Mr. O'Keefe to sit at counsel table for the duration of the trial, that Mr. Taylor believes that he is not capable of managing all of the witnesses and the evidence and conducting the proceedings on behalf of you during the trial, that Mr. O'Keefe's presence at counsel table is essential for the efficient and effective representation of Ms. Benefield's case, that because of the complexity of the defense, the inordinate number of issues, the many witnesses, the discovery that encompasses thousands of pages, Mr. Taylor says it's too much for him to handle by himself. And then when you add in the audio and video matters that must be taken care of, he's not sufficiently skilled to assure that smooth presentation. And he's not able to divert his attention from the many trial responsibilities to attend to those matters. Also, that Mr. O'Keefe is necessary to be at the table so he can respond to questions and issues that you have without having to divert Mr. Taylor's attention from the testimony. And in the memorandum portion of the request, that this is a complex homicide case, and given the magnitude of discovery, number of witnesses, and anticipated length of trial, the undersigned is simply not capable of exclusively providing the quality of representation that Ms. Benefield is entitled to. Now again, I appreciate Mr. Taylor allowing me to do this. These are his words, but I think he understands why I'm having this colloquy, is that I wanted to be sure you had read these and you understand these things, because I certainly want it on the record that you are aware of what he has said, and that if I don't grant the request for Mr. O'Keefe to be at counsel table, the concerns that he has expressed about his effectiveness at trial. So are you sufficiently aware of what's in the affidavit and the request and the memorandum of law?
I am, Your Honor.
And it is your choice to keep Mr. Taylor as your attorney?
Yes, Your Honor.
Okay. All right. That's what I want to do. I want to have that colloquy and make sure that everything was out and you understood that and you had read those documents and you were aware of it. I certainly know and understand, and I know that Mr. Taylor is well aware of his obligations under the rules of professional conduct. And if you want to ultimately set this for hearing at any time, I'll be happy to hear it.
I frankly thought the court was going to rule on it today.
Well, it wasn't noticed for today.
Your Honor had said, correct me if I'm wrong.
Oh, what I meant was I needed to hear because I wanted to have the colloquy. I didn't mean to also intimate that I was going to make a ruling on it as of today. So I apologize. If it came across that way, I apologize. My intention was to have this colloquy, make sure that Ms. Benefield was aware of the request, aware of the...
All right, quickly for some context, the judge had ruled that the paralegal who has been on the case from the very beginning could be in the courtroom, but he would have to sit in the bench in the gallery. And the defense is saying, look, I need him at the table because of all the work he's done, and I may not be able to be effective counsel without him there. So the judge wanted to make sure that this client, this defendant knew that and was aware that these claims were being made by that attorney. All right, we do need to take a break right now. We'll hear more of the judge's conversation with defendant Ashley Benefield when Court TV returns. Keep it here on Court TV.
One of the most successful true crime TV shows ever.
This is crazy.
Now has a new home on America's original true crime obsession, 48 Hours, on Court TV. Coming up next on Court TV.
Tonight on Closing Arguments, our verdict watch continues in the case against Karen Reed. We'll break down what could be having the biggest impact on this jury as deliberations continue.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
All right, folks, before we get you back to court, let's bring back in our guest, still with us, criminal defense attorney, former prosecutor Marie Pereira, and child attorney and law professor Joe Richardson. Joe, I'm going to start with you. Interesting claim being made by this very experienced attorney, 74 years old, been at the bar, I think the judge said something like 50 years. He's basically claiming that he needs this paralegal, very experienced, been with him throughout the preparation for this case. It's complex litigation. Without this guy sitting at the table next to him. Now, again, the judge said he could sit in the gallery behind him, but in this motion, which I have in front of me, says he doesn't want to constantly have to turn around to deal with that because he's going to deal with him all the time. Needs him at the table in order to provide effective assistance of counsel. At least he's saying, I don't know if I can be effective without him. What do you make of the judge putting it on the record, but also the request being made by this attorney?
Well, certainly, I think the judge is right to put it on the record to make sure that the client, the defendant, has her eyes open and says that she wants him to be her attorney, to continue to be her attorney, while knowing that he is stating in order to be effective, he actually needs the paralegal, basically saying he won't be effective without the paralegal sitting next to him. Now, it raises some larger questions about why you take the case if it's not guaranteed that the paralegal will be able to sit with you up at the table. How long has it been since he's had these cases, even though he's very experienced, et cetera? And I could see where you would need some paralegal help with a huge documentation case, but does that mean they have to be next to you? So it's going to be interesting to see how the judge comes out on this situation, because this seems to be an all or nothing proposition. Literally, if the judge doesn't grant this motion, this sounds like this attorney is saying that he cannot represent her effectively.
Yeah, it's almost like Marie, he's actually like being crafty. He's setting up an appeal based on ineffective assistance of counsel. If the judge rules against him, almost extorting the judge on some level. The judge doing, again, the right thing, putting it on the record, but crafty move, or do you think it's legit?
You know what? I think his complaint is legit. As a person who calls myself Wilma Flintstone in computer age, I need my grandson to help me log on to Court TV. So he's not saying that he's not a good attorney. He's simply saying there may be some demonstrative tools that he doesn't know how to use because he's not a computer person. It sounds like something simple, but to a person who's not a computer person, I could understand him. And I don't see what the problem is to just let the paralegal sit next to him if he needs to pull something up, click this, close this window, just to help him. It's not speaking on his ability as an attorney, because I'm an attorney and I'm a nurse and I don't even know how to use my phone. Doesn't mean I'm not competent to do the job of an attorney. Give a brother a break. Let the guy sit at the table. Come on.
Yeah, I mean, some courts don't like to have officers who aren't, people who aren't officers of the court sitting in the well. Again, I don't know what this particular judge will do, but it seems like he may have some rules because it necessitated this motion on behalf of the defense. All right, stand by, guys. Let me get folks back into court now for more of that motion hearing.
Averments made in the request and the memorandum, aware of the sworn statements in the affidavit and the perhaps repercussions if the court does not allow Mr. O'Keefe to sit at the table, which is completely a matter of discretion whether I do that or not.
Yes.
I didn't want, I guess, to be in very frank layman's terms, I wanted to have this colloquy because I did not want this request and this affidavit to be Exhibit 1 at a 3850.
I understand, Your Honor, and I did not file that for leverage to put the court in that kind of position, which is why I had no objection to the court speaking to my client today. I filed that motion, Your Honor, because as gracious as Your Honor has been to allow Mr. O'Keefe to sit on the bench, that's going to force me to turn my back on what's going on here. I can't afford to do that. I've got too much going on. I've got too many witnesses, too many issues. I need help. They have 2 assistants. I'm by myself. Mr. O'Keefe doesn't have to even be introduced. I just need the assistance in actually providing Ms. Benefield with an adequate defense. The irony is, I believe it will assist the judicial economy and allow this case to proceed a whole lot more smoothly. Because the truth is, and I don't have any problem falling on my sword here, I am not skilled audio-visually in playing and retrieving all the things that we intend to bring up during the course of the trial. And I've got my hands full with all the other trial responsibilities.
Understood. Like I said, we've still got a little ways to go. I'm going to defer on the ruling of that. I'd like to hear a little bit more. I want to see how kind of things play out and where we're at a little bit closer to trial.
Does the court wish for us to set it for a hearing?
It's up to you. It's something I'm going to have to address pre-trial, so it'll be something. I think I might have asked you guys, I think a while ago I asked you guys to go ahead and book the week before trial a 1-hour hearing because I want to do my full colloquy. I'm sure every judge has their own, well, I know they do. Every judge has their own pre-trial colloquy that they go through, kind of going through all the different issues. I've got my own ways of explaining and what I allow and not allow during voir dire. There's an entire colloquy I do with the defendant to make sure that she's understands everything and is ready to go to trial.
But would the court anticipate when it says a hearing on this motion an evidentiary hearing? Or just
I wouldn't think so. No, I think it's just going to be a discussion.
Okay.
I don't see it as evidentiary. Quite frankly, when we do the actual hearing on that, I don't think she needs to be here. I wanted her here for this colloquy.
Okay.
But whenever we argue that, I don't think she needs to be here.
Very good. All right, thank you, Judge.
Judge, my only concern, and the defendant, she may have said this, but I didn't get that she answered, if you do say that Mr. O'Keefe cannot sit there, is she still okay?
That's an issue for another day because I haven't made that decision. I specifically did not ask that question. Getting into hypotheticals, permutations, and combinations of what can happen in the future. I just wanted to make sure that Ms. Benefield understood that this is a discretionary matter, and if her attorney has said, but she has the absolute right under the Sixth Amendment to her choice of counsel.
I completely agree with that, but she's not going to be here for the next hearing. So
I'm sure they'll let her know.
Okay. But then if
we show up at trial, that's why I said, let's talk about it now, because if I don't allow him to sit at the table and all of these things come true, I don't want to hear it at the 3850 or whatever judge is presiding over at 3850 if all those things happen.
So if you would like to probe this a little bit, I can tell the court, and Ms. Benefield would confirm this, that Mr. O'Keefe entered the case approximately, I think, 10 days following the actual homicide, maybe even less than that. And from the day I entered the case, as soon as I sat down with Mr. O'Keefe, he was my lifeline. And he has remained my lifeline since then. He has provided me with invaluable assistance because there's a lot to be done here. The court has seen the motions and everything that have been filed. Now, I have come to rely upon Mr. O'Keefe in assisting me in defending this case. Ms. Benefield is well aware of that. In addition, because of his earlier entry into the case, he has a position of absolute trust with Ms. Benefield. Ms. Benefield feels that she can ask him questions which he is capable of answering without having to divert my attention. The court knows, having done trial work, if I'm answering a question, I may miss a statement by a witness that's critical. I can't afford that.
All right, so that wraps up our coverage for today. The judge has complete discretion, and he will decide at a later date.